fair housing laws, rights, and responsibilities. Purpose of fair housing laws is to prevent discrimination in housing by making it illegal to disadvantage someone in renting, buying, or occupying a home because of that person's membership in a protected class. Broken down, what this means is that fair housing goals are simply to prevent discrimination in housing and to allow for equal access to housing and housing. There are 6 protected fair housing classes recognized by federal law: race or color, sex or gender, religion, national origin, family or familial status, and disability. Federal law recognizes that you may not be discriminated against in housing on the basis of any of these 6 protected categories. California adds 3 more protected classes on top of the ones that were already mentioned. California law dictates that sexual orientation, source of income, and arbitrary traits may not be used to discriminate against people in housing. To remember these different protected classes that are in California as well as in the federal government, we have 2 different mnemonics you can use: acid frogs and grand furs. Let's try acid frogs together. Arbitrary traits is for A. C is for color or race. I is for source of income. D is for disability. F is for familial status. R is for religion. O is for origin, as in national origin. G is for gender or sex. And S is for sexual orientation. Take a minute to try it again and see if you can remember all of the different protected classes based on one of these 2 mnemonics. The discrimination laws which we're going to be focusing on, the 2 big ones that we want to talk about, are the Fair Housing Amendments Act, which is known as FHAA, and the regulations which accompany it. And that is the federal law. And then we have the California law, which is known as FEHA, or the California Fair Employment and Housing Act. There are also disability laws at both of either the federal and the state levels, which you should be aware of. There's Section 504 of the Rehabilitation Act of 1973. This is known as Section 504. Title II of the ADA, the California Civil Code 54 and its ETSEC, that's Equal Rights to Public Facilities, and Executive Order 13164. These particular sections have to do with disability laws, which state that you may not discriminate on the basis of a person's disability. Additionally, we have several civil rights laws which help us in this as well. The 1866 Civil Rights Act and the UNRRA Act, known in California as the California Civil Rights Act, are both pieces of legislation which you should look at if you're dealing with discrimination laws. So let's talk about a couple of these protected classes which may not be so straightforward. Familial status, for example. Familial status is when you're looking at an individual who actually has children, and by the way, that's children who are under the age of 18, or the person can be pregnant, or have custody or guardianship of a child, or be in the process of adopting a child. The person can also be a foster parent. So really, when we're thinking of familial status, we're thinking of someone who has children in the household or who is about to have children in the household. And that's what's going to form the basis of a familial status discrimination complaint. It's not the situation where you have, for example, your uncle living with you or your grandfather and you're an of-age adult. Then discrimination in that particular context may fall under arbitrary traits, but it would not fall under familial status because there's no child under the 18 who's involved. Gender and sex discrimination, just to note that this law also covers sexual harassment. It prohibits deliberate or repeated verbal comments, gestures, or physical contact that create a hostile environment for tenants. For example, if you have someone asking sexual favors in exchange for housing or repair services, then this can actually be gender or sex discrimination on top of sexual harassment. And so if you have someone coming to you for a sexual harassment issue, then this may be something to look at on part of a fair housing discrimination complaint as well. Disability discrimination. Disability under the federal law means someone who has a physical or mental impairment that substantially limits one or more major life functions. This is the federal law definition, and the state law definition is actually quite broader than this. Now, you may have a history of impairment, or you may be viewed as by others as having an impairment, but not actually have an impairment today. But if someone is discriminating against you because they believe you to either still be disabled or be disabled if you never actually had a disability to begin with, then you will fall underneath this category and you can make a complaint for disability discrimination. So let's talk about some of the major life functions. Remember, this can be either a physical or a mental disability, and here are some of the major life functions which can be disrupted: walking, hearing, breathing, working, seeing, speaking, learning, or caring for one's daily needs. And you can see how multiple iterations of these types of activities or activities like this would be disruptive to somebody who had a disability who is not able to carry on major life functions like these without specific alterations to their lifestyle in order to make that happen. There are specific prohibited actions when we're talking about disability discrimination. Under the Fair Housing Act, it is against the law for a landlord or someone who is offering housing to actually ask about the disability unless the tenant is requesting some sort of accommodation or applying for housing that gives priority to persons with disabilities. So if there's no actual reason to know about a disability, then they can't actually ask about it. Now, if the tenant is asking for a reasonable accommodation, say they need a ramp built so that their wheelchair can get up to the side of the house, then it is okay for the landlord to ask about the disability. However, if there is no request made, or if the housing is not specifically geared toward persons with disabilities, then asking about it is illegal. Secondly, the landlord or person renting the unit may not ask a tenant to provide more documentation than is necessary to prove the disability. So if, for example, the tenant requests a reasonable accommodation, and the reasonable accommodation says, we need this specific thing to happen in order for us to be able to enjoy our apartment, then the landlord is entitled to get certain documentation, for example, a letter from a doctor which says that this is necessary. However, the landlord is not allowed to require the tenant to provide more documentation than is necessary to prove the disability. Additionally, the landlord cannot ask a person with a disability to prove that they can live independently. It is unlawful for someone to ask the disabled individual whether or not, based on their disability, if they see someone coming up, for example, to rent, whether or not they can live by themselves or if they need someone to live with them. I should qualify that by saying they can ask if they're going to need space for them, but they do not have to prove it. So they can say this person is coming in as my IHSS worker, but they don't have to prove that that person needs to be there to assist them with their disability. They can just say that the person has to be there or is taking care of them, and that should suffice. So who is subject to the fair housing laws? The answer really is any housing provider. So that includes landlords, that includes anyone who's renting a room, that includes anybody who's putting up a sign for rent in their yard, and it also includes housing authorities and those who provide, for example, public housing, Section 8, and other low-cost housing. So what is illegal? All forms of discrimination in the sale, rental, or financing of a house or apartment, or in the provision of housing-related services on the basis of race, sex, national origin, religion, family status, or disability. The reason that I have the provision of housing-related services bolded is because this is the part that people often forget. Not only in sale or rental do we have to think about, but when thinking about any housing-related services, if it's related to housing in any way, and you are discriminated against on the basis of one of these protected categories, you may have a complaint for housing discrimination. The Fair Housing Amendments Act applies in every state, at every transition in the housing process. So you don't currently have to be a tenant in order to claim that you were discriminated against. It applies to advertising. It applies to the application process and screening. It applies to the terms and conditions during tenancy, and it even applies at the end of a tenancy if it were to come to eviction or termination. So if, for example, someone is seeking to rent an apartment and is being refused on the basis of his or her race, then just because they're not a tenant yet does not mean that they do not have fair housing rights. Quite the contrary. Putting in an application and being discriminated against is fair grounds for a HUD complaint. Prohibited conduct. We'll talk about these all a little bit separately. Intentional discrimination, disparate impact, sexual harassment and domestic violence, failure to provide reasonable accommodation, and predatory lending. Let's talk about each of them now. Intentional discrimination is when the landlord or the person who's letting the apartment refuses to rent or sell or lend to someone on the basis of their membership in a protected class. Or for example, they discourage applications from people who are of a certain gender or of a certain race. Or they create different terms in the rental agreements or rules, telling one family who has children under the age of 18 that the security deposit is going to be $3,600, and then telling a couple with no children that the security deposit will be $1,200 is against the law, and it's an example of this type of intentional discrimination. Segregation through advertisement, steering, or physical separation is also intentional discrimination, as is different treatment in the application process. While you're a tenant, if you notice that certain people are getting more response to their request for repairs than others, then it may also be a case of intentional discrimination. Responding differently to requests for repairs based on a protected category is intentional discrimination, as is differential enforcement of lease provisions or house rules. Going after certain folks who break the lease provisions, but not others, or strictly enforcing the house rules on certain tenants because they are a part of a protected class is intentional discrimination. A reasonable accommodation is a change in a rule, policy, practice, or service that is necessary to allow a person with a disability the equal opportunity to use and enjoy a dwelling. Under federal law, the housing provider must provide reasonable accommodations, and there are only two exceptions to this. Number one would be that reasonable accommodation is not related to the person's disability, and the second would be that it would fundamentally alter the nature of the provider's operations or would impose an undue financial and administrative burden. It is important for all landlords and housing providers to pay attention to reasonable accommodation requests. The only thing that the tenant has to do is supply, either orally or in writing, I highly recommend in writing so that there's a paper trail, but supply something which tells the landlord or housing provider what the problem is and the reasonable accommodation that they are requesting. It's important for the tenant to actually say how their disability relates to the reasonable accommodation that they are requesting. So, for example, asking for rent notices or any notices which are going to be put out by the housing complex to be done via phone instead of via taping a piece of paper on the door because the individual tenant happens to be disabled and happens not to be able to see or have visual ability to read the notices would be an example of a reasonable accommodation. And the reason they have to be paid attention to is because if the landlord does not respond to the reasonable accommodation, then they could be found to have discriminated against the person according to their disability under the fair housing laws. And it will be treated the same under the law as intentional discrimination. So even if they were just negligent, they just decided not to act quickly enough or move on the reasonable accommodation, the law will treat it as if they are intentionally discriminating against the tenant with disabilities. The requested accommodation must meet the requirements of the fair housing laws in order to be considered a reasonable accommodation as defined by those laws. But like I said, as long as you have a nexus between what that particular disability is and what rule or policy is being requested to be changed, then that should be no problem. And a reasonable accommodation can be made at any time, in the very beginning of a tenancy, during a tenancy, or even at the end of a tenancy if you're facing something like an eviction or a termination. That brings us to fair housing enforcement. So what happens if you actually find that you may have been a victim of housing discrimination? Well, it's important to let somebody know about that. There are a couple of different agencies who work on these particular types of enforcement complaints. Bay Area Legal Aid, for example, does that for the Bay Area here. An administrative complaint can be filed with HUD or DFEH, that's the Department of Fair Housing and Employment. You can actually go to Bay Legal and they'll help you with this. And what the HUD complaint does is the HUD complaint lets HUD, which is the federal government's housing unit, know that there's something going on with a particular landlord or particular housing provider in that they are not following the federal rules for fair housing. HUD often shares the responsibility of investigating this with DFEH, which is the California Department for Housing, and they together investigate the claim and look into the tenants' problems that they've been having with their landlord over the time that they have been a tenant there. Additionally, you can engage in civil court action, administrative mandamus actions, civil fair housing lawsuits in the state. You can also bring lawsuits in the federal court for damages and or an injunction. So you can bring lawsuits in the federal court either for money or to get them to stop treating you in a certain way or to stop the discrimination. We have at the bottom here the HUD's phone number. It says Dare to Be Fair. It's the 1-800 number at the bottom, which if there is a problem, you can actually call HUD directly and let them know what's going on, and they can route you through the appropriate channels. Lastly, discrimination is a defense in unlawful detainers, which is the California eviction lawsuit. If the tenant is being evicted and they believe that the reason they're being evicted is because they are being discriminated against based on a protected class, then they can use that as a defense, an affirmative defense, in their unlawful detainer case, and they should discuss this with the attorney that they're working with.